Before we proceed with the Affia case in New York regarding that poor kid that was left on the school bus, it's worthy of our time to come back and take a slightly closer look at the Virginia and Maryland Railroad Company case. Let's review the key concepts. Very important. We established that this guy here and this guy, Chief Justice, we established that they, according to our analysis at least, it looks like they're wrong. Why is that? Why is this conclusion of theirs that, number one, the decedent failed to see what was there to be seen, that a reasonably prudent driver in his position would have slowed down, necessarily so, / reasonably so, and that's why judgment should, as a matter of law, be reversed? I'll tell you something interesting. These are two guys that joined in on this dissent. I'm going to assume that the appellate panel there had 5 judges or justices. Yeah. That means they won on what I fully understand to be the correct decision, shown here. It took one guy to make the difference. If one guy saw things differently, he would have had it the other way. So last time, we essentially endeavored to find an answer to this question. Did the driver act reasonably or with ordinary care, being in the position that he was? The fact is that for a finding of negligence on the part of that driver, Mr. White, to be found or to be made, it'd have to be the case that necessarily others in his shoes would, across the board, distinctly not have failed to, it has to be the case that others would have failed to end up in... forgive me, I'm all over the place here. It would have to be the case that others in his shoes would not have failed to end up in a necessarily and distinctly different situation or outcome, given the realistic, real-time pressures and constraints of the situation. We can answer that question intuitively. We know, we established last time, intuitively, we could feel that something about that situation was a little too dangerous. Ordinary people, reasonable people exercising their ordinary level of care, not all of them would have made it safely over within that situation. I think we could feel that. For that reason, there is no negligence on behalf of Mr. White. What I think is interesting to look at here is the explanation. Now, here's a key method to the process of finding and holding the successful or the finding the correct judgment successfully. You've got to be able to go back to the material, reread it again, and then understand with new, fresh eyes why it's wrong. Where exactly they go wrong. Now, remember the Affia case? They talked about the standard of knowledge, and the debate was, does the person on trial, did he need to have actual knowledge of wrongdoing or constructive knowledge of wrongdoing? Is it the case that he actually needed to have known and been aware of wrongdoing, or is it enough that he did something where he should have known, regardless of whether he actually knew? The matter was correctly, case law before that time or prior correctly held that you actually need to know that you're doing wrong. Well, let's transfer that standard here. Looks like they're confusing something in the railroad case. The dissenting judges say that he knew or otherwise should have known that the crossing signals were out of order. Now remember, all holdings, all matters of fact, and all matters of law established within the proceedings anywhere must be admitted and must pass that first and perpetual threshold of the reasonableness standard. That is, if reasonable minds all across the board would agree, then and only then can you say the thing and believe it. Well, you know what they say is their justification here for the regarding their line of logic? Because there are some ropes hanging somewhere from around there at the time. Probably earlier that day. And he should have seen them when he was driving that morning. That's the only reason we believe that that the dissent believes that he shouldn't have gotten into that accident. Because there were ropes there earlier that day. Well, let me tell you something, guys. Let's apply the reasonableness standard. Would every person driving on the road that day have distinctly, surely noticed ropes on some railroad crossing? And furthermore, what does that mean? Does that mean that the signal is out of order? Are we sure? Ropes could mean anything. See, if there was a sign there saying railroad alarm crossing safety guards are out of order, that establishes reasonable cause for all people to understand now that that is broken, and that they will keep in mind. And then even if you remove the sign later, but something doesn't look quite right, that will stick in the mind. And then they will say, oh, well, I remember I surely have within my actual or constructive or subconscious awareness that something wasn't right here. Yeah. But there's some ropes hanging around somewhere tied up. Maybe he was focusing on the road that morning. Maybe he was intently tunnel visioned on the only thing that's supposed to matter when you're driving, which is the actual lanes in front of you and perhaps the car that was next to him doing some maneuver nearby. Maybe he was more worried about another condition on the road at that time. He didn't turn his head and observe the ropes. Not every person in that situation would have caught that. And furthermore, we don't know what ropes mean. It almost meets the level of reasonable cause to believe that the thing is broken. Almost. It's close, but prudent thinking would slightly shy away from necessarily holding that's what it definitely means, and therefore we ought to also be just as careful when we're driving back later today. Something's not landing here. We know what actually happened. We can step into this poor man's mind and literally relive through maybe he was an old man. Maybe he was north of 40 years old or 45, and he had some slight dementia starting to set in. That, with the fully legally acceptable amount of alcohol that he and all drivers on the road are legally allowed to have in their system, that and the age factor, if it is a factor, means, and it's night, and maybe his vision isn't good. Because guess what? They test for your 20/20 or 20/40 vision. They don't test for your night vision, your color reception. There's another thing. After 40, everybody tells me, you lose your ability to really see at night, to see things in quite the same way. And there's no standard for that, to test that as a driver. No, you're not seeing the world the same way. Those are half the drivers out there. Okay, what possibly could have been old man, very, very slightly tipsy mind combined with a sort of naivete about, what ropes? What the hell does that mean? I don't know. So he approached the train tracks on his way home. He saw or should have seen, well, I believe he should have seen, and I believe he did see, 3 cars completely stopped in the right-hand lane, because it would be almost impossible not to notice. However, apply the objective reasonable standard, the same one that's for police officers. See, in those cases when things are moving quick, there's a bullet flying here, there's a person there, we're not sure who they are, could they be a threat? With the practical constraints of the situation, that is how you judge the situation, and not by the hindsight of 2020. We know this. Same here. What do those 3 cars mean? Huh? That's funny. Well, all I know is that I don't hear the bells, and I know that for 20 years I'd hear the bells every time that there's any issue, reason to stop. So, what are these idiots? Oh, shoot, dead. Yeah, it only took, a fraction of a second longer to hold a naive line of thinking. Anyone's susceptible to that. He exercised ordinary care, all right, as soon as he slammed his brakes down. That's it. It's not negligence. He didn't fail to do anything. He didn't fail to think correctly, because anybody in his position under those live wire circumstances would have been almost just as susceptible to being trapped in the same sudden, unexpected trap that situation created. But now, there's one more thing I also wanted to cover that we didn't really touch upon last time, but it's important, and it will be important further down the line in a future episode, not too far from now. All the things we're touching upon are going to start converging and tying in together in a very significant way. Sometimes the judges are very astutely analyzing a situation, narrating the story for us, the readers. And then all of a sudden they stop, their brains go to the dogma, and then they recycle dogma with trust me, I know what I'm talking about. They recycle the dogma verbatim, like good, dutiful members of whatever position you're filling there societally. And then after you're done reciting the dogma, you go back, your eyes straighten up again, and then you regain presence and start smartly analyzing the thing again, okay? We're going to find a lot of that. You'll see these aren't just words of mine to, bash anybody or any group of people. Judges' work is extremely important. But let's start finding some of these very tiny hidden things hidden away right under our noses. Here's what they state, as a matter of fact. The conclusion of the trial court, whether it relates to negligence, causation, or any other factual matter, cannot be ignored, or maybe the evidence regarding those things. And then they go on to say this, as if this is a doctrine or a controlling principle. Courts are not free to reweigh the evidence and set aside the jury verdict. They mean appellate courts, of course, their court, the mid-level appellate court that we're dealing with here now. We can't simply set aside a jury verdict merely because the jury could have drawn different inferences or conclusions, or because judges feel that other results are more reasonable. Oh. Is what the majority, who arrived at the correct decision overall, by the way, is what the majority said there, strictly and technically perfectly correct? Is that correct case law? Let's think about it. What is just in society? Imagine this. Let's say you're involved in a court case. Very simply, we'll take for granted that in actual reality, as a matter of true from God truth, you are the one who's right. But let's say everybody else is human. Your righteousness, your actual objective, from God looking into the oracle crystal ball, that you're the real one who's right. But you're living in a world where everybody's eyes are twisted. So what's the function of a correctly working system? It's to prevent any and every possibility of you being screwed when you actually are right. Now, the name for that screw is called being prejudiced. Trial courts have a responsibility, a lawful responsibility, to weigh the evidence correctly. All verdicts must be based on reason. Everything in the proceedings must be based on reason. So when therefore a finding is reached, and imagine God sitting up there hypothetically knowing, we know that's not the correct one. The humans messed up again. Okay? The trial court ruled in favor of the other guy. So, what's your first line of thinking? Well, number one, if we know all verdicts must be based on reason and according to actual reality, and all reason supporting it, or that you could draw from actual reality in order to inference your correctness if you did it right, if you weren't incompetent, this is the only reasonable conclusion you could have reached. But somebody just, every member of the jury and the judge, are hungover from last night. No, I don't know. Nobody thought. They just want to go home. They flipped the coin. They're these are not good people. They just ruled in favor of the other guy. What protections does the system offer you? You're supposed to be able to appeal. Now, given that, again, you're the real one who's owed remedy, what are the obligations of the appellate court? It's to protect this. It's to protect your access to this, your remedy, which is the preservation of your rights on account of you being right. So it's a very funny thing for them to say. You go back again, and we're going to start discovering a lot of funny things that man has messed up over the decades and even hundreds of years, but 90% of the mess-ups happened in the last 20, 30 years. Whew. Wonder why. Oh, I'll have another channel explaining why that is. But anyway, go back to this. Again, everything else made sense, and all of a sudden they just kind of start singing from the dogma train from their minds. Courts are not free to do what? To correctly get it right? No, something's not right here. Now, it's worthy to point out that in a civil case, it's about who's right as a matter of what the preponderance of the evidence suggests. But we're going to be working with a lot of criminal cases. In criminal law, it's not a preponderance of evidence that must support a conviction of guilt. It's that your innocence, as a practical matter, would need to be virtually implausible as a matter of established fact for guilt to even be considered to be rendered. Imagine trial court gets it wrong. You're right, but you're sitting behind bars now. Uh-oh. And now you have to appeal. Of course you're going to appeal. They rule in favor of the other guy, or they rule in favor of the state. I'm going to tell you something. If the jury could have drawn different inferences, it means they didn't do their job correctly, which prejudiced you as a matter of what the result was that ended up affecting your life. Of course, you are supposed to fix what's broken. If it's very apparent that a jury made incorrect inferences, or rather, that inferences drawn, and by the way, what's a reasonable inference? These are the only types that are allowed in the proceedings. So, hold on a second. All things admitted as into the law, into the proceedings, into the trial, into the courts, into the cases as a matter of a threshold minimal standard for admittance has to be that different inferences are impossible. Different inferences are necessarily unreasonable in order to foster and support that the one inference you did draw is what's called reasonable. It means nothing else is. Nothing else is reasonable. The opposite conclusion is necessarily unreasonable. That's why the one and only inference with regards to the facts is the one we made. If it's for sure that you could have drawn different inferences, it means the inference you did make wasn't reasonable. Regardless of whether or not it actually happens to be correct or not, it means it's not reasonable. So you failed to meet the standard of the law. So of course that's a huge glitch prejudicing the party here. This fails to be recognized. So let's see this. Is this bad case law? They quote some cases. I'm very curious to see what their justification is to say that this principle is the most perfect manifestation of just procedure. This technically could, if taken out of context, this could violate due process. This could violate the proper process that is due a defendant. And by the way, on this one, if a judge makes a determination that a different result necessarily is more reasonable, well, then you're really in trouble. Don't give yourself false restrictions that incorrectly trap you from saving victims that are denied their rights. Never do this. This might be bad case law. Let's see. We'll look at this. We'll look more deeply into this very soon, but it's an interesting matter to bring up now because this is going to be a theme that comes back quite a number of times. By the way, let's compare this to something else. Let's keep this case in mind. From 1964, out of the state of Colorado. We'll be reviewing it more in depth in an episode coming up very soon. But for now, from that case, where acts or circumstances in life and in the proceedings as we're deliberating about them are attributable to either an innocent or a criminal cause, the innocent hypothesis will be adopted. What is this saying in other words? If the conclusion is not a reasonable one, meaning reasonable minds would not fail to differ on that finding, therefore, you don't have the necessary standard required for guilt, and that's why the innocent hypothesis must be adopted. Very clear. So therefore, if we know this is true, because this one is plausible and this one is also plausible, and yet, despite that fact, you're sentenced, when you then go on appeal, would it be correct? Let's say you're actually innocent. Or let's say you're guilty, but the evidence doesn't support it. Either way, you are entitled to your freedom. Going back to the Virginia case here. Imagine you're in a position in a criminal case. You know you're innocent. Say you are. You're wrongly found guilty, and then the appellate level court, the only one left that can save you, they simply sit there and go, hey, Courts are, we're not free to reweigh the evidence just because they could have drawn different inferences or conclusions. Even though, yeah, I'll even agree, I felt the other result definitely more reasonable. Would have applauded that other result. We're so smart. We figured out that something's not quite lining up here, but we're not free to really do anything about it. No, you would pull your hair out and say this is disgusting. This is not a correctly functioning system. This is hell. You're not allowed to make hell. So somebody's screwing something up. We'll find out soon. When we get to the bottom of everything. Yeah. We'll check out these maybe and some other similar issues soon with this. Back to this case, People versus Afia. Usually I like to go over the case the first time, the opinion that narrates the circumstances in the story. And, let the reader consider everything first before, coming to a conclusion, before deliberating with oneself. I couldn't even hold it back here. We were reading through this last time, and boy, as we were reading, it just screamed out about how off and almost insane, seemingly, in my opinion, this opinion was. Okay? We went over this. Now, what's interesting here in this case, very interesting. Actually, rather, I'm not sure if it was a judge or a jury. I can't say for sure. Regardless, somebody who's tasked with screening the situation to make sure that the person who is at risk of losing things is protected, such that only virtually definitely guilty people are allowed to be even possibly exposed to the risk of actually being sentenced. We discussed the matter of mens rea, which is the guilty mind in Latin. This was required. Let's take a look at the relevant controlling sections of law in this particular state that affect the Afia case. Let's look very closely. I think it's interesting. First of all, we always got to start. Most important place, definitions. An act means a bodily movement. A voluntary act means a bodily movement performed consciously as a result of effort, as a result of determination. Without effort and determination that's conscientious, that is not a voluntary act. Omission means a failure to perform an act as to which a duty of performance is imposed by law. Consider this very carefully. Omission means exactly this and only this: a failure to perform to which a duty of performance is imposed by law. If the duty isn't imposed by law, that's not an omission. Keep that in mind. Conduct means an act or omission. Again, an act is either affirmative movement or otherwise that which is steered by effort or determination affirmatively. Non-affirmatively, that only applies if there's an imposition of law. Beautiful. You guys got to see everything. Because conduct means an act or omission as married with the accompanying mental state. That's the important thing. Was the mental state accompanying the act or omission that which suggests the presence of mens rea, the guilty mind? Or was the mental state forgetfulness? Oh, this is not mens rea. To act means either to perform an act or to omit to perform an act. Culpable mental state. That's the modern slang for mens rea. This means intentionally, that is, with intent, or said differently, a certain endeavor that has a specific purpose in mind. It could be knowingness or awareness. There could be recklessness or criminal negligence. Let's see what these things mean. Intentionally. A person acts intentionally with respect to a result or to conduct described by a statute defining an offense. When that person's conscious objective is to cause such result or to engage in such conduct. Stop right here for a moment. Every single statute that says, that holds the requirement that a thing needs to be done with intent, it means that there must be reasonable finding, a reasonable holding, that there certainly, clearly and convincingly is the conscious objective to cause the result prohibited. A person, Miss Affia, was found guilty of the attempt to commit a crime. But according to the law, to our societal covenant or social contract, a person is guilty only when you engage in conduct which tends to affect the commission of a certain crime, when you also have the intent to commit that same such very crime. You have to intend it. And what is intention? Conscious objective. Let me ask you something. Can we draw reasonable inference from the circumstances described to us in the People versus Affia case? That this woman actually necessarily / reasonably so carried the conscious objective to cause the endangerment of a child? Not only does it fail to be the case that reasonable minds would all find that to be the case. If reasonable minds could differ, that's enough to find them to acquit. No. It's actually all the way over to the other side. That's called a screw job. We can all actually see 99.9 out of 100 people would all agree in unison. We would fail to differ in finding that, of course, you didn't have the conscious objective, Miss Affia. How the hell did they find you guilty of this? Guilty of what? Guilty of knowingly endangering. Intentionally attempting to knowingly endanger the kid. Neither the knowingly part of the endangering was there, nor the intending to endanger knowingly was there. It's all a scam. What the hell, in my opinion? A person acts knowingly with respect to conduct or to a circumstance described by statute defining an offense when that person is aware that the conduct is of such nature or that such circumstance does exist. Period. And to note, since we covered this in our first episode, it's good to define the terms and understand what these things mean. Interesting distinction between recklessness and negligence. A person acts recklessly with respect to a result when he is aware of, but nevertheless consciously disregards the substantial and unjustifiable risk that something bad is going on. Criminal negligence, on the other hand, interesting. It's when there is a substantial and unjustifiable risk sown into a certain situation, but he actually genuinely fails to perceive it. So with recklessness, He perceived it, but he didn't care. He chose to ignore it. Negligence is, I really didn't perceive it. But there's a little more, of course. The caveat is that the risk must be of such nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. Guess what? Now, almost no crimes listed in the statutes in the criminal law use this standard. Almost everything applies with, if it's not a strict liability crime, it has to be at least recklessness, and usually it's either knowingness or with intent. Very important. Why was the trial court wrong? Number of reasons. First, no actual intent can reasonably be inferred. That intent is required in order to find guilt with regards to the attempted commission of a crime. Along the same lines, no actual knowledge of wrongdoing is inferable either. All I can see and tell from the circumstances is that at the very least, I see the woman made a mistake. I don't have enough information, evidence-backed, that is, which is required, to bring the whole of reasonable minds necessarily over, that they couldn't disagree on the matter, like, oh yeah, it's definitely clear now. She totally knew that she was doing something there that was creating the criminal risk. It's not there. And it's amazing when we realize these things for ourselves. We literally went to the law, used logic, came back and said, yeah, this isn't intuitively correct. We can all feel this. Nevertheless, whatever the hell ended up in the drinking water by the year 2007 started to take effect. Oh, ha ha ha. Okay. You like my jokes? Someone said there's half truth in every joke, but I don't know anything about that, right? It's just a joke, see? They literally admit the issue in this case is whether these facts, all as shown here, as we fully covered last time, are sufficient to convict the defendant of attempted endangering the welfare of a child. I already told you guys. First of all, strange enough that they couldn't actually sustain a charge of actual endangering of the welfare of a child. So they think that if you put it as attempted, that's easier because we can't find. So they admit that we can't find guilt for her actually doing it. So how you gonna render justice? You know what? Let's make a backroom deal. Maybe we gotta make her punished somehow. Maybe the law doesn't allow it, but we can pretend that we don't understand English. Hold on a second. Attempted. Go back a second. Right? Attempted. All right. But then go back here. That would make sense then. The issue in the case is, right? All that without direct proof that the defendant actually intended to endanger the child. Under the circumstances of this case, we hold that they are, and she's guilty. Whoa. Guys, there's no hidden secret here. There's no additional explanation. You're probably sitting here going, hold on, where's page 2? Where's the next page? Right? Where they actually explain something that would justify that whole, finding of guilt. No. We went from beginning to end, my friends. That's it. Oh, that's a sobering realization. We read together how the defense actually correctly cited cases where they said, look, you have to have actual knowledge. You can't infer that. Also, what they didn't do, the defense lawyer didn't bring up the issue with attempted. This is even a more significant hurdle than the knowledge criteria. They stretch the law too far. That's not law. That's make-believe. You're not allowed to make-believe. Guys, it's really sad. I don't know why. But this Victoria M. Affia, who's the defendant, looks like it was a legal aid society that represented that defendant. Seymour James and Ivan Pantoja. Uh-oh. Let me ask you something, guys. Why didn't legal aid? Why didn't they appeal? As a result of a lack of an appeal, at least one that I can find, this poor woman's life was ruined. She's labeled a criminal. That's a criminal right there, my friends. Somebody who makes a mistake. No. Let's try to back into this. You guys remember where acts or circumstances are attributed to either an innocent or criminal cause? That is, she was in the bus, she walked down, she may or may not have seen him. Did she turn the head? Did she know she was not looking, or did she have a brain fart? Well, the attendant facts of the case and everything you can reasonably infer, and admitting nothing else than only things one can reasonably infer, I can't really distinguish or tell the difference between her purposely being a sick person, playing Russian roulette, like, let me purposely pick 3 seats to not even look at and see if the kid happens to not be sleeping or sleeping. She's not some sick person doing that. I can't distinguish whether it was that or whether she had a brain fart. You can't either. That's why the innocent hypothesis necessarily must be adopted as a matter of law. Except only one problem. Imagine an appeals goes through in that court. Then what? God forbid that they try to pull this as an excuse. Guys, we might have some problems in the law. It's time to start uncovering them quick.
Occupation.
Robert Wilson Cody. I'm what you might call an axe grinder.
Mr. Cody, please tell the court how you know the defendant.
He was my employee.
And how would you characterize him?
Honest, trustworthy, intelligent.
Ask him if he's aware that the charge against me is a lie and that everyone here knows it.
It's immaterial. He can only testify as to character.
Just ask him.
The judge will rule it immaterial.
Ask him, or I'll fire you.
Mr. Cody, are you aware that the charge against Mr. Oliver is not only a complete lie, but that the judge, the plaintiff, and every citizen here know it?
Objection! Immaterial. It has nothing to do with the character of the accused.
Sustained.
Wait a minute, miss. You're saying this is a trumped-up charge, and you're all in on it?
Immaterial. The witness is ordered to ignore the question.
Well, I'm not going to ignore it, Your Honor. If what she says is true, it's a very serious matter.
Well, serious or not, it's immaterial to this hearing. Next question.
Whoa, Judge. I asked her a question, and I want an answer.
You don't ask the questions here, Mr. Cody. You answer them. And if you don't do what I tell you to do, I will hold you in contempt.
Hey, I'm not answering any more questions until somebody answers mine. Why don't you tell me, Judge? Are you in on a lie here?
I fine you $500 for contempt.
Answer my goddamn question, Judge.
$1,000 and 90 days in jail. Bailiff, Sergeant, put Mr. Cody in a cell.
Whoa! Hold the phone, boys! This is dynamite. We'll all go out with a bang if anyone takes another step toward me. Gentlemen, just drop your guns. Everyone else, stay seated. Judge, stick your finger up your nose. I'm not kidding! I'm terminally ill, and I'll gladly take you all with me to hell right now! Judge, I said stick your finger up your nose.
You better do it, Judge. I know this guy. He says what he means what he says.
I'm glad we understand who's in charge now. So, Judge, this whole deal was a lie. Is that right? Keep that finger in your nose.
Yes.
Yes, sir.
Yes, sir.
All right. Show of hands. How many here knew this thing was a railroad job against Mr. Oliver? liars, lawyers. Mr. Oliver, how do we teach these liars a lesson?
Now read it, Judge.
By this order, all legal actions, charges, fines, and fees against any non-citizen of Moorlaw in any matter pending before any Moorlaw court are hereby dismissed, and I declare an unconditional amnesty.
Thank you. Bailiff, make a few hundred copies of that, post it all over town.
You know, this is an interesting town. I think I might just stay here.
You got a problem with that, Judge?
No problem, sir.
You guys got to start waking up. We have before us the case of Chester versus Zima from the trial level court in New York. It says Supreme Court, but most people out of the state of New York don't realize that, for some reason at least, in New York, they call it the Supreme Court. That's actually the lowest level court in the state. That's the trial court level. The top court has a different name. That's the Court of Appeals. 1964 in Erie County, this case comes up. What's going on here? In this case, a woman, Mary Ann Chester, finds herself as a plaintiff. This woman claims injuries. Not a tremendous amount of detail is provided in this particular court opinion. However, we can infer that Miss Chester here is suing Zima on account of Zima being alleged to have, at least by reasonable cause, there's reasonable cause to hold that Zima may have caused injury to Chester. So, let's go over something interesting. And in fact, this is a very interesting case indeed, because this position of Miss Chester's, this can happen to absolutely anybody, to you and to me. God forbid, let's say you or I or any one of us finds himself, unfortunately, to be the victim of an accident. Driving down the road tomorrow, boom, little crash, little injury. Oh. Alternately, let's say you went to a hospital. Maybe for that injury, maybe for another reason, completely unrelated. Most recent time you went to the hospital, it may have been for any reason. Let's say the doctor there didn't do what he was supposed to do. No. You end up getting injured, or there ends up being some other kind of problem where they're legally liable. Or in a car accident, other person's legally liable. Now, doctors have insurance. So do drivers. This is where things get interesting. Now, you're going to sue. If you were injured, you're going to sue to get compensation because the other person made a mistake. They were negligent or reckless. Or worse, God forbid. So here's what's going to happen. You're going to sue. This is a personal injury case. Okay. You're claiming you were hurt? Yeah. Happens all the time. Every day. Everywhere. Once your suit is in, the other side, the defendants, the ones who did this to you, they're the ones who should be scrutinized very closely, right? But here's instead what's going to happen. Happens every day. There's going to be a demand made to you. The defendants, the ones apparently or allegedly responsible for what happened to you, they're going to say, yeah, we want to see, since you claim you're injured, right? That's right. You or so-and-so injured me on precisely that day and on that time and in that circumstance, and you injured me. I was fine earlier that day. You injured me, and now I'm injured. Oh, okay. Well, you see, maybe it wasn't the accident that caused that knee injury. Huh? What are you talking about? Well, I say it was. That's what I put and swore to in my complaint. Maybe that's what you say, but maybe it wasn't us that did that. Maybe you had a knee injury before. How do we know you didn't? Well, you have no reasonable cause to believe that, but no. We don't. That doesn't matter. No. You see, we want all your medical records. Oh, you mean my medical records from that day when I got hurt? No. No, well, of course not. I mean every doctor you ever visited in the last 7 years of your whole entire life. Pardon, what? Yeah. Every single medical record going back the last 3, 5, 6, 7, 9 years. Just 'cause we say that we want to see it, yeah. Huh. Okay, hold on a second. Now, I didn't have a crystal ball 5, 6, 8, 9 years ago. I didn't know I was getting injured by you today. I didn't count on it. You just came out of the blue and injured me by surprise. Now, before that, I was living my life. I was going to my doctors for completely unrelated medical conditions. There may be an HIV condition, a schizophrenic condition, or any number of other extremely private, sensitive, embarrassing, and otherwise privileged content and information. I relied on there being a level of privacy. I was pretty sure that such privacy and the privilege to keep my doctor-patient communications personal and kept private, that is a privilege that is afforded to me by the protections of my law here in this state. So if I say my medical information is privileged and protected, you can't just decide that it's not, or that you're going to help yourself to my medical records anyway. So, no thank you, and good day. But they say, listen, you know who we are? We're insurance companies. You want to see how deep our tentacles go? Watch this, everybody. Hey, Judge. Make that man or woman there, order them to forcibly disclose all their medical records. Now, listener, you would laugh and say, well, the judge isn't going to do that because the law clearly protects a person. And we'll look into that very shortly. You would laugh and you'd say, well, obviously that stuff's not relevant, and only relevant things are forcibly, there's a right to forcibly compel or order the disclosure of such things in a case. That's called within the process of discovery. Well, surprise, surprise. At least if you're here in New York, you're going to be ordered to forcibly reveal your private information. That's right, guys. That's right. I can't break into your doctor's office to look into the cabinets and find out your private medical information that's written there. No, I can't do that. You know how I can find your medical information? All I have to do is walk up to you and smack you over the head with a bat and injure you today, just because I feel like it. Because when I do that, or I'll run you over with my car. I'm going to do that so I can get access to your medical records. You'd say that's crazy. I'd say that's what New York law, that's exactly what New York law supports and allows by extension. In the abstract. But it's possible for sure. Here's how. I'll run you over with my car. Then you'll sue me. Then me / the insurance company that I have on my behalf Yeah. We'll just say, hey, maybe you didn't, maybe your head was caved in before that accident happened. How do we know? You'd say, well, you don't have reasonable cause to believe. That's old stuff. Today we twist things however we want. Money talks. What? You're crazy. Get out of here. Boom. Judge just ordered you to reveal 9 years of every doctor you ever saw. I get to personally review those things. Oh, trust me, if I don't have a lawyer, I'm the party. I can lay my eyeballs on your private stuff. I win. This is like psycho-dominance. How do you like that? Is that a broken law? You bet. So let's go back and read this amazing case. Because this is not really where it all started, but where things begin to go cray-cray. And we're going to track the line of insanity until we find out exactly where we are today. But more importantly, we'll identify why it's insane. But first, let's give this judge a chance and evaluate. Is he right or is he wrong? What's the operative principle of law? What's fair? What's fair? The defendants, possibly an insurance company, or it doesn't really matter. The defendant served a notice requesting the plaintiff who was injured, that woman who was suing, that Marianne Chester, to sign authorization forms that permit these defendants to examine, that means take a look at, all the records of all the hospitals. In this case, not in every case, trust me, records relating to the physical condition that is in controversy here in that particular suit or action of the plaintiff Marianne Chester, pursuant to Section 3121 of the CPLR. Now, the plaintiffs brought this motion for a protective order because the defendants were bothering her or them, saying, we want to see your medical records. We want to see your medical records. She says, you're not going to do that. She turns to the judge and says, Judge, protect me with a protective order that prevents them from trying to get to that obviously protected stuff. She moves for that protective order to restrain those defendants from enforcing the demands that they made, the demands that she provide the signed, today it would be the signed HIPAA form. Back then it'd be whatever it was back then. That's the authorization to let them see your private privileged stuff. She moved for that protective order on the grounds that such authorization and inspection by those defendants, it would obviously violate the doctor-patient privilege, which existed. Exists is the word, Mr. Judge, not existed. Oh, pardon me. I gotta read first. Existed under the previous laws of the state. In the 1960s, they had recently renovated the law, so to speak, put into effect a newer, modern version of the law that still runs to today. That's the CPLR, the Civil Practice Laws, Law and Rules that govern civil cases. A reading of the disclosure provision, Article 1 of the CPLR, indicates, the judge believes, a clear intention to open the door of pretrial inquiry to the point where as much of the information that's material relevant to the issues at hand that are also normally in the sole possession of that one party, as those doctor's records in her doctor's office, I believe they may be obtained by the other party in the interests of truth and justice. Very nice sing-song. Interests of truth and justice. To remove the element of surprise from litigation and to enable the litigants, that is the parties, and the courts at any proper stage of the litigation to be able to make that true evaluation of the merits of the cause, that is the cause of action, why they're there, they're suing, and what the rights are, truly, of the parties that are there before the court. In any circumstances where the disclosure would, in the court's opinion, be such as to cause, quote, unreasonable annoyance or expense or embarrassment, seems like it could be pretty embarrassing, actually. But it continues on, or disadvantage or other prejudice to any person or the courts. The court has broad discretionary power to limit the demand and inquiry and to suppress information obtained. Here's a little trick. The court has broad discretionary power. Whenever you see that word discretion, it means the court believes it can freely decide one way or another. That is misapplied. For when you're dealing with privileges, you don't have that power. That's a fact. We'll get into that shortly. We're previewing that concept now. So, again, these learned judges, very interesting. Many of them, most of them very respectable, but you're not supposed to be able to get up to that level unless you're virtually perfect at your job. But what is this? We know that discretion and privilege don't mix. So you're using interesting wording to misquote, shift the context around a little bit. Oh, that's not good. Oh, I wonder to what ends. Let's find out. The right given by Section 3121 for an examination of the hospital records of any party, or in this case plaintiff, coming here and suing because she claims she's injured, the supposed right given by that subsection, it's not a right. We'll analyze those in very soon. That right is indicative of the trend. Oh, it's trending towards full pre-trial disclosure, which in that judge's own personal opinion, the provisions of Article 31 of the Civil Practice Law and Rules are intended to accomplish. Where the plaintiff brings a lawsuit here based on a claim for personal injuries, that plaintiff consequently removes himself, judge esteems and holds, from the provisions of Section 4504 of the Civil Practice Law and Rules, that is, the law that asserts that confidential information between doctors and patient is, which tells us that unless the patient him or herself waives the privilege, a person authorized to practice medicine shall not be allowed to disclose anything regarding the communications between them. Records, information, you're blocked. That privilege, furthermore, belongs to the patient. So, if that's ordinarily true, can anything override that? The judge in Chester v. Zima here says that anytime you get hurt in a lawsuit, and then you make a lawsuit, I believe that's when you remove yourself from the protective provisions of 4504. As to doctors' reports and their confidentiality, as hospital records and their confidentiality, at least to the point where that plaintiff must comply with the demand for examination and copying of those records in full. By the way, that's not just sending the records over to the other party. This is, in effect, allowing the publicizing of that information. Okay? So, here's a funny thing. For the last 7-10 years of your life, you may have been relying on the protections afforded to you by law that you can speak to your doctor honestly, truly, about anything you want because you know it's guaranteed to be protected. Well, that's what you thought. You relied on the law as it appears, but you relied on that law to your own detriment, because you foolishly believed and therefore opened your mouth more deeply and more deeply confessed the true things. And then they did tests, and you see some real interesting things that you keep private. Well, if I run you over with a car on purpose tomorrow morning, I get to go see it and then publicize it in a public court case about your HIV and your schizophrenia. How do you like that? Boom, control. Sick. How do you prevent sickos like, not me actually, but sickos who'd be like that? How do you prevent that? That's called prejudice. So are you interpreting the law correctly? Oh, something's wrong here. Judge goes on, in the absence of a showing on a motion for a protective order that specific parts of the hospital record should not be made available, the protective order should not be granted. I'm not here to represent the interests of, people who might be, victimized in any way or really genuinely prejudiced. Forcibly have your most private stuff ripped open into the world, whatever wolf wants to come along and see it. Hey, but remember, guys, when we're dealing with insurance companies, they know what they're doing. You see, maybe it wasn't the accident that caused that injury. And hey, once we have ripped away from your most private medical records, we're going to find all sorts of interesting theories as to every wrong thing that ever happened to you in the last 10 years. Any of those things could possibly contribute to your lack of well-being right now. That's going to make you, makes us pay less. We're very smart. Yeah, it is all about money. Welcome to the world, my friends. We're going to pull apart this scam, what I believe is a scam in essence. It's a racket. This is one of the least talked about things in the law today, and I'm going to be the one to make it one of the most talked about things. Game's over. 70 years. I'm blowing it open. You're welcome. Judge here continues, this was placed an intolerable burden on the courts and would delay, if not defeat, the aims and purposes of the law. The demand for authorization was to permit inspection of any and all hospital records. Oh, he did them a little favor, though. Plaintiff's not required to execute such a broad authorization. That's too broad. So we're going to narrow it so that only the records relating to the injuries that are alleged will be all that the defendants may have. Okay. Plaintiff's motion for protective order is denied. He summarizes at the end. That's Chester versus Zima from the 1960s. You want to find out what kind of precedent that's set here in New York? Oh, come with me. We're going to track it all. But first, maybe I already hinted to you guys what the real answer is, but question of the day. In Chester versus Zima, did that Judge Gilbert King, normally I don't name judges, but there's a specific reason I'm going to name a judge, and I'll explain why later. So here I'll name him. Place specific attention on the human being in that seat and not just the court that judge embodies. Did Judge King rule correctly in ordering for the abrogation of the plaintiff's privilege of communications made in privacy? Look one more time. How does he justify it? A reading of the law generally? I believe that the trend is what he says, is, disclose everything. Eeny, meeny, miny, mo. Force you to rip your privacy open, and I have no respect for you. Thanks for watching, guys.